Hi, I'm Josh Escobedo with Weintraub Tobin.
Hi, I'm Scott Hervey with Weintraub Tobin. Welcome to another edition of The Briefing by the IP Law Blog. So today we're going to be talking about a case, Mango versus BuzzFeed. It was a recent case decided by the Second Circuit. It's not the most interesting of cases, but it does present novel issues, and that's why we're talking about it. Josh, you want to roll us through the facts of the case?
Absolutely, Scott. So the plaintiff in the Mango versus BuzzFeed case, Mango, was a professional photographer. Mango took a photograph of a plaintiff in a prominent piece of litigation in New York, which was subsequently covered in an article by the New York Post. The New York Post reached out to Mango and obtained a license and properly attributed credit to Mango in their article. A couple of months later, BuzzFeed decided to run an article on the same topic. Only when BuzzFeed published their article, they stripped the photograph of any attribution, and there was no mention of Mango in their article. Scott, could you walk us through the legal issues?
Yeah, so Mango promptly filed a lawsuit against BuzzFeed and pled two counts. One was a count of copyright infringement, and the other was a count of violation of Section 1202B of the DMCA. And that section addresses the removal or alteration of copyright management information, or CMI. So CMI, what's that? You were probably asking yourself, and rightly so, you should be. The term copyright management information, it includes the following: the title or other information identifying the work, the name of the author of the work, or the name of the copyright owner of the work. So obviously, when you think about the credit Mango got in the New York Post, it probably says photographed by whatever his first name was, Mr. Mango. That satisfies or qualifies as CMI. And the Section 1202, so what it does is it creates it makes unlawful the removal of or alteration of copyright management information and the distribution of any work that has altered or removed CMI, where such action, either knowing or with constructive knowledge, that such action will induce, enable, facilitate, or conceal an infringement of any right under this title. And it's Title 17, so it includes a copyright infringement. So
Scott, in short, that means we have one count that is expressly seeking a remedy for the violation of the copyright. And then the next count, which is under the DMCA, is for the ancillary conduct of stripping the attribution, which is essentially a prophylactic measure to protect people's copyrights. Do I understand that correctly?
Yeah, I mean, that's the whole purpose. The DMCA was enacted in 1998 really to address concerns about online infringement and make unlawful ancillary acts, or acts that tended to be ancillary to online copyright infringement. And one of them was the circumvention of measures that control access to copyrighted works. And another one happens to be the removal of copyright or alteration of copyright management information. So this is an interesting Section 1202B is an interesting section because it has this double scienter requirement, right? Actual knowledge that the CMI was altered or removed, and then two, constructive knowledge that such removal or alteration may induce, enable, facilitate, or conceal an act of infringement. And on appeal, the Second Circuit had the opportunity to address the novel issue of whether this act of infringement was limited to a third-party claim or otherwise. BuzzFeed's position on appeal was that it had to be a third-party later infringement and not their own. And the Second Circuit said that the plain reading of the statute didn't support BuzzFeed's position. An infringement is not limited by actor or by time. While future copyright infringement by a third party may constitute an infringement, the Second Circuit held that nothing in the statutory language limits it to such later infringement. BuzzFeed's infringement was an infringement under 1202B. its awareness that it was distributing copyrighted material without proper attribution potentially concealed its own infringing conduct, thereby satisfying the DMCA's second or double scienter requirement. So you might be asking yourself, like, what's the point of all of this? Well, the point of all of this is that Mango got additional recovery. Mango was entitled to statutory damages under the Copyright Act for BuzzFeed's infringement, and Mango was also entitled to statutory damages under the DMCA. And on top of it all, Mango got an award of attorney's fees. So it was a pretty lousy day for BuzzFeed. And it's a message, I think, for online publishers, or people whose works end up being online. And I'm thinking of television production companies whose television shows might end up being distributed online as well. If you're going to infringe a photographer's photograph, make sure to give him proper attribution. I'm Scott Hervey.
And I'm Josh Escovedo.
Thanks for listening. Thanks for watching. I really hope you liked that last video. If you want to see more content, please subscribe to our channel. And if you're interested in more in-depth analysis on intellectual property law issues, please visit our blog at the IP Law Blog.